Swayam Prabha. Digital India. Educated India.
So, friends, continuing our discussion on writs, which are an important tool for enforcing fundamental rights guaranteed in the Constitution. Uh, I told you there are five writ orders that are issued by the court. These are orders based on what we call as the writ petition that is generally filed in either the High Court or the Supreme Court. So, writ petition, when we address this word, it's different from a writ order. So, habeas corpus mandamus prohibition, certiorari, and covenant or writ orders based on what has been the aggrieved individual's plea and whether he has been able to substantiate the same, and whether the court has found it necessary to review the petition of the plaintiff, and whether the court seems it so necessary to intervene in the matter and issue such a writ. So, based on all of these, I think you will notice that to safeguard the interest of citizens, to control the power of the state, to regulate public administration, to look at the doctrine of separation of power theory, the judiciary has been bestowed under the Constitution of India with the absolute and fundamental power of judicial review and issuing these kinds of writs to different sectors of public administration. Now, please note, while we say public administration, we have spoken about the constitutionality of a legislation, that is checks and balance rule on the legislative competence sometimes, or the legislative necessity. For example, friends, the Supreme Court did say that National Judicial Appointment Commission's bill was unconstitutional, which is called the NJAC bill, because the courts have retained their independence and autonomy by holding that act of the parliament as unconstitutional. That act attempted to balance the power of the executive with the power of the judiciary in making appointment of judges to the superior courts. National Judicial Appointment Commission's bill. So, in that sense, the writ jurisdiction is a very broad jurisdiction that may check the power of the parliament. As recently, you will notice that the abrogation of Article 370 and Article 35A of the Constitution, in which special status to Jammu and Kashmir was created by the Constitution, the government did remove this special status. And the same was taken before the Supreme Court. So the Supreme Court now is going to decide whether the actions of the government is valid or not valid, whether it is constitutional or not constitutional. Similarly, the power of the police, as I told you, habeas corpus, the power of the executive administration, mandamus, the power within the judiciary itself, because judicial review of the judiciary is also an important aspect of public administration. And what I would say, instead of using the word public administration, the appropriate word will be administration of justice. So these institutions are involved in the administration of justice, and hence prohibition and certiorari are the writs that relate to them. Of course, if you look at some landmark cases on writs, you will notice that, for example, the writ of certiorari was issued in the Karak Singh versus State of Uttar Pradesh case. It's a 1963 judgment of the court. It's actually a very important case, which also speaks about the right to privacy. Because in certain cases you will notice that the courts have intervened in certain matters where they have done a violation of certain errors of fact that they might have committed, or they might have exceeded their jurisdiction, or they might not have followed the principles of natural justice. See, judicial and quasi-judicial authorities are supposed to act fairly. They're supposed to act in a non-arbitrary manner. and with reasonableness. And they have to provide an opportunity of being heard to the parties. They have to be transparent in their administration. And the writ of certiorari has been utilized by the Supreme Court to ensure the same, where either administrative or quasi-judicial authorities have not followed those kinds of principles in terms of administration of justice. State of Bihar versus Kameshwar Singh, the Supreme Court held that the writ of prohibition is utilized to prevent inferior, I would not use the word inferior, rather lower courts or tribunals from surpassing their jurisdiction as well. Now, coming to the fact, friends, the ADM Jabalpur versus Shivkant Shukla case, this is popularly known as the habeas corpus case. You will notice that when citizens move the court for the enforcement of their fundamental rights, they can definitely do so. But are some of these constitutional remedies suspended during emergency? Now, we know that emergency was imposed in this country in 1975 and 1976. And when such a national emergency is imposed by the government, you will notice that the power to impose such emergency does exist with the government or with the Union Cabinet under Article 352 of the Constitution of India, where the state of emergency can be declared by the President. And you will notice that some of the rights may have to be suspended in national interest, because emergency is a time when national interest is deemed to have been adversely impacted, and hence, we'll have to make a choice between what can be exercised as fundamental and what cannot be exercised as fundamental. Now, emergency power, we'll probably deal with that in some detail later on, but how does it impact Part 3 of the Constitution is something that we have to discuss right now. Now, please note, as a foundation of an individual's existence in a given society, an individual wants to, develop his intellectual abilities. He has to fulfill his spiritual advances, and he must adhere to his responsibility as a citizen within the ambit of law and order, morality, and public policy. Having said this, please note, the original constitution gave certain fundamental rights. Okay, so let us list those fundamental rights right now. For example, we have the right to equality, we have the right to freedom, we have the right against exploitation. Okay, so if you think we should go back and read the articles of the Constitution, let us reiterate this. Right to equality is between Article 14 and 18. Right to freedom is between Article 19 and 22. Right against exploitation is Article 23 and 24. And right to freedom of religion is between Article 25 to 28. Cultural and educational rights are Article 29 and 30. Right to property was there under Article 31. And finally is the right to constitutional remedies under Article 32. Now we know right to property is now no longer a right? And it is just a legal right under Article 300A of the Constitution. So currently we are only discussing 6 categories of fundamental rights. Okay, originally we had 7, now we have 6, right? I'll calculate the 6. Right to equality, 1. Okay, then right to freedoms, then that is 19 to 22. Right against exploitation, right to freedom of religion, cultural and educational rights, and finally constitutional rights. So 6 rights. Now, one must appreciate that rule of law clearly says that none of your rights, whether it is fundamental or legal, are going to be absolute. Right? It's not like you have the rights completely and you can do whatever you want with it. Every right has some scope of what you can do with it, and every right has some limitation of what you cannot do with it. So the limitation on rights either can be imposed by the Constitution itself, or one can infer it by the law on public administration, and of course how public policy is determined from time to time, because that can be very dynamic. What was public policy in terms of limitations to fundamental rights in 1970 can be different, and today it can be entirely different, because remember, as I told you, we have had this 4th generation of rights, Initially, when we got independence from the British colonized kind of a rule, we were looking at what we call as the first generation of rights called civil and political rights. Right to vote, having your democratic government, having your own government, establishing your own policies, etc. etc. So these were the initial struggles that our forefathers who adopted and gave us this constitution had to undergo. Then slowly, as the society progresses, the state, country progresses, civil and political rights probably got a little bit kind of settled, and then you have to move on. You have to look at fair elections, in civil and political rights, so that the democratic process is ensured. Then you move forward and have your cultural and economic rights. That's the second stage of rights that citizens generally enjoy. Now, cultural and social rights or economic rights would mean right to development, what you can do as a right to business, right of movement, so on and so forth. Having your own property, your house, income, and so on and so forth. So, cultural rights could mean, please, you have your faith, you have your religion, you have your language. So these are protections that are done in the second generation of rights. Then third generation of rights, you come to a stage where you talk about the quality of life. It's not just the life. Quality of life becomes a critical factor, and then health and environment become very very critical. So the courts post 1990 looked at regulating private businesses, stopping their greed. Uh, uh, you know, so all of these became the third generation of rights. Today, you are in a stage where there are fourth generation rights. So please note, every generational right had its own scope for the right, and they had their own limitation to the same. So that is what is the public policy that is laid down by any process of governance. And please note, public policy cannot be uniform in a country like India, which is so diverse in terms of its geography, its language, its culture, and it may differ from time to time as well, from one generation to another. So, if you talk about your fourth generation rights, you can talk about rights of homosexuals, rights of transgenders, gender equality in places of worship, so on and so forth. So, they're endless. These are the fourth generation of citizens of this country who demand a different set of rights for their determination. Because, see, they know that the country is safe, okay, national security is safe. They know that the political process is already done. Culturally and economically, okay, we are well off post 1991 thanks to liberalization, privatization, and globalization. Now, you need some other rights, right? So we did develop that kind of fourth generation, right? But having said all of these rights, some could be fundamental, some could be just legal. One must understand that these rights are granted in the hope and aim and purpose that it will only do public good, right? It will serve you better. It will make you more intellectually, more developed, and the country would progress, and you'll be a country that becomes a superpower. You can look at scientific innovation and so on and so forth. So the $1 trillion economy, the fifth largest economy, or the third, wherever you want to achieve, you progress, in multidimensionally in terms of GDP growth. However, what is the limitation for fundamental rights? I think the limitation has always been that some of the fundamental rights ought to be subservient to the social good, to the social cause, to public order, to public morality. Now, we'll talk about morality more importantly in terms of constitutional morality. Today, that's the new test of morality. And then finally, the safety and security of the state. So you can't compromise, right? So when it comes to the safety and security of the state, I think what will prevail, if suppose there is a conflict between protecting fundamental right and safety and security of the state, I think overall one would easily come to the conclusion that the safety and security of the state would have to be given prominence, not fundamental rights, right? So I think fundamental rights, not being absolute, are to be governed with reasonable restrictions. The word reasonable is very important. Restriction, of course, will tell you limitations on the exercise of your fundamental rights. But the fact remains, whenever reasonable restrictions are imposed, either those that are stated in the constitution are to be implemented, of course, right? So we say public order. What exactly in a given situation is public order due to which your fundamental rights have been curbed, infringed, abridged? That would be subjective to that case, to the place where it has been invoked or imposed. And hence, those kinds of restrictions, please note, are always subject to judicial review. they will always be subject to the fact of whether those restrictions are justiciable in nature and character. Right? If they are, of course, the court it will pass the test of constitutionality, and the fundamental rights may probably be curtailed or restrained because of the necessity of maintaining public law and order. So, can fundamental rights then be suspended during emergency? Uh, which of the fundamental rights can be suspended and which should not be suspended? Right. So, you will notice that there have been some very interesting cases where this has been taken about, and the courts have held that for example, in one of the cases called ADM Jabalpur versus Shukant Shukla, which was a case of what we call as habeas corpus case. The Supreme Court at that point of time, please note, 1976, just after emergency, though in this case the dissenting opinion then becomes a majority opinion in the Menaka Gandhi case. The court did say that Article 21, that is right to life, can also be suspended. But in Menaka Gandhi case, it was held, no, it cannot be. See, right to life at any given cost of whether it is an emergency or not, should not be suspended. Right? So, at any cost, even during emergency, Article 21 will continue to prevail, and the state is duty bound to protect that life and not infringe or abridge. I think this has been a very significant ruling in terms of whether uh, uh, the most important fundamental right, Article 21, can be suspended during national emergency. However, what about Article 19? The 6 freedoms that we have under Article 19, freedom of speech and expression, movement, business, and so on. Can they be suspended during an emergency? For which the answer is yes, they can be. And in some cases, please note, if you refer to Article 358 of the Constitution of India, Article 358, it specifically provides that the suspension of Article 19 during emergency can take place. So the Constitution itself says 19 can be done, but 21 should not be, because thanks to what the Supreme Court has done in the Menaka Gandhi case. So, when can Article 19 be suspended? Which kind of emergency it can be suspended? When the proclamation of emergency is done, to ensure the security of India or any territory thereof, if it is threatened by any kind of a war or external aggression, then Article 19 can be restricted by the state by making any law to that effect or through executive action which the state thinks is very much necessary in those matters. However, once the proclamation of emergency ceases, then automatically you will notice that the rights under Article 19 shall be restored back. So, reading Article 359, one would come to this conclusion that except Article 20 and 21, most of the fundamental rights that we have discussed can be suspended. Okay, you should read Article 359 to get some more understanding of the same. So there is a very clear demarcation. 20 and 21 are not to be, compromised during proclamation of any kind of an emergency, but rest of the fundamental rights can be definitely affected. So once the proclamation is over, because you can only proclaim an emergency for a certain duration of time, not more than exceeding 6 months, unless it reasonably is required. And hence, in those circumstances, you will notice that once emergency ceases, then automatically your fundamental rights gets reactivated, and you can exercise your fundamental rights and enjoy the same as well. So, the 44th Amendment Act of 1978 did put some kind of a change. I think that was relevant in terms of how suspension of fundamental rights are to be viewed. So, suspension of fundamental rights can happen, and that presidential order to that effect is generally issued, but it has to be presented before both the houses of the parliament, and those are the procedures that are laid down in terms of how this is to be exercised. Um, yeah, so I think that should be kind of a good discussion, because ADM Jabalpur said 21 can be suspended, but then Article 359 very clearly now states that except 20 and 21, no such rights can be suspended. So, going back, friends, to Article 226 now. As I told you, we are discussing the writ jurisdiction of the court. So, let us take the High Courts as well and take it forward. Now, the power of the High Court under 226 is very similar to the power of the Supreme Court. But as I told you earlier, 226 is far more broader and wider, because High Courts are in every state. Now, there are benches of the High Court also in different cities. The High Courts are the constitutional courts. Please note, they are not ordinary courts, they are constitutional courts. And hence, they also have an original jurisdiction in accepting writs. So, a citizen can directly go to the High Court without going to the lower court in case there is a violation of two rights. One, fundamental, which is very clear, like 32. But then, additionally, even for the violation of a legal right, a legal right can be established by a statute, it can be established by a law of either the state assembly or by the parliament. So it is a normal right, but not so very fundamental that is mentioned in the constitution. But it still has the power that it shall not be abridged, it shall not be infringed, and the state has a duty to protect that kind of a legal right. And in case a citizen feels aggrieved or violated, then he can approach the High Court very, very directly in its original jurisdiction as an aggrieved individual or a party. Now, please note, 226 also has been utilized for public interest litigations, of course, because the right to life and hence the dilution of the locus standi principle means that anyone who is in public interest can approach and seek the protection of his fundamental or legal right, not only for himself, but for someone else in a public cause, in social interest. And that is something also provided under Article 226. In a significant case called L. Chandrakumar versus Union of India, this was about Article 227, because Article 227, friends, is a very significant power of the High Court to have what we call as the supervisory jurisdiction over all courts within its territory. So you say High Court of Karnataka, you say High Court of Tamil Nadu. It is called the High Court of Madras sometimes. So once there is a High Court in a particular territory, then every other court below it, be it proper judicial court or even a quasi-judicial kind of a court, shall come within the supervisory jurisdiction of the High Court. And hence, the High Courts can exercise their powers under 227 as well. And in this case, I think what the court held in L. Chandrakumar was that the Parliament of the state legislature cannot intervene or exclude the jurisdiction of the constitutional courts. The constitutional courts are supreme at any given point of time. Taking away the power of the constitutional courts or limiting the power of the constitutional courts will be completely against the basic feature of the constitution. It cannot be done so. And this is an integral part of the constitution, having Article 32 and 226. So, no tinkering, no amendment, no kind of interference can be done in these two articles. So, I think with this, we should conclude constitutional remedies under 32 and 226 as well. And we should conclude part 3 of the Constitution with this discussion. I think we will move on to part 4, which is on the directive principles of state policy in the next module.